Assalamualaikum warahmatullahi wabarakatuh to Dr. SYAMSUDEEN. My name is NURIN BINTI MURSHIDI and I will be presenting on my part, which is the introduction. So, a trade union is an organization of workers and employers who are employed in a trade, occupation, or industry on a temporary or permanent basis to pursue legal goals. Trade union works as a voice to govern relations between workers and employers in order to improve good relations, improve both parties' economic and social status, and find ways to increase production efficiency for the benefit of all parties involved. In a capitalist country such as Malaysia, it is important to join a trade union because it can protect the interests of the trade union and provide them rights. Among the reasons for the workers to join a trade union is to ensure they are given the rights such as the protection from the mistreatment in the industry or unfair dismissal and others. In particular, the members of the trade union prioritize their rights so that the goals of the union are preserved. What is rights? Rights can be translated to basic moral standards concerning what is authorized or obligated to individuals based on any legal system, social norm, or ethical philosophy. In the case of Malaysia, it has a specific act that protects the rights of the members of the trade union, which is the Trade Union Act 1959. The act had laid down the rights given to the trade union under Part 4 that includes the right to legal action, the right to financial support, the right to be represented in court proceedings, and the right to industrial action. These are all of the rights that are possessed by the members of the trade union.
Hi and Assalamualaikum to Dr. SAMSUDEEN. My name is NURIN binti NAZRI, and today I would like to present my part, which is the right to be represented in civil or criminal actions. First and foremost, the rights of a trade union as stipulated in the Trade Union Act 1959 is the right to be represented in civil or criminal actions. According to Section 25 Clause 6 of Trade Union Act 1959, a union has the legal right in any civil or criminal proceedings in which a registered trade union is a party. Such trade union may appear in such proceedings by any one of its officers or by an advocate and solicitor. Any registered trade union and every member of its executive who fails to comply with subsection clause 3 or by an order of the Director General under subsection clause 4 shall be guilty of an offence and shall on conviction be liable to a fine exceeding 1,000 ringgit and a further fine of 100 ringgit for each day on which the offence continues. As we can look forward under subsection clause 3, any member in an organisation who started and vice versa are acting to be as a continuation of a strike. Any members in an organisation from a trade union who took part in a strike and break a rule under subsection clause 1 must be quit from being a trade union members, and apart from that, the members are disqualified to be a member of a trade union except with the approval from the Director General written by written, and trade union workers who are being stopped from a trade union must be cut down their name from being registered as a trade union workers. In addition, to tell the Director General or trade union members about the blacklist of their name, besides that to exhibit clearly in the register office the list of the members whose names are being blacklisted. Director General can take legal action if subsection clause 1 had been breached by the trade union members and were failed to carry out the provisions under subsection clause 3, or if there is an excessive delay to do it. The name of the members in a trade union who broke the subsection clause 1 and subsection clause 3 needs to be removed as soon as possible from its membership list. Okay, that's all from me. Thank you.
Assalamualaikum warahmatullahi wabarakatuh to sir. My name is SITI binti SHAUTHI and will be present about my part, which is right to take legal actions. Because the freedom to join or establish a trade union is a fundamental right of workers, employers must respect workers' right to join or organize a trade union in order to engage in lawful trade union activity. A trade union is an organization that help employers and employees work together in the workplace, and workers or employees organize trade union to act as go between workers and employers, which resulted in more harmonious labor relations. In addition, labor unions play a key role in bargaining with employers for better working conditions and a better social standing for workers. Besides that, according to Section 35 Clause 1 of Trade Union Act 1957, a union has the legal right to file a lawsuit, and it can also be charged for providing services. They should also be informed that such membership may pose some risks, as well as their legal rights and who they can contact if their company fails to provide them with the benefits needed by law. Employees must recognize that their rights are accompanied with obligations. As a result, employees are expected to receive the pay that is owed to them under their contracts, while also doing their best to finish the work that has been assigned to them. Employees also cannot be used by the employers and vice versa. For example, in the case of Ahmad Zahri Mirza Abdul Hamid with AIM Cyberjaya Sendirian Berhad. In this case, the appellant was engaged on a series of fixed-term contracts for a period of several years. When the contract was up for renewal, the parties couldn't come to an agreement on certain aspects. Therefore, the respondent decided not to renew it. Based on the evidence, the court determined that the appellant work with ADC was not one-time, seasonal or transitory, as it remained continuous from 2009 to 2013. The corporate will should have been leave as a result. The work permit was not a problem in this case, since according to Article 8 Clause 1 of the Federal Constitution, all workers should be treated with fairness, dignity and equality. The appellant's citizenship had no influence on whether or not he was a permanent employee or on a fixed-term contract. In addition, employees also have the right to file a written complaint with the Director General if they believe there has been a violation of the trade union rights, besides by stating all of the facts that lead to the complaint. The Director General can take whatever actions or investigations he deems necessary to resolve the problem or complaint. If the Director General is unable to address the complaint, the Minister must be notified, and the case will be referred to the Industry Court for a hearing. Following that, the court will have a trial and reach whatever decisions it considers appropriate for the employee. Next, according to Section 35 Clause 2 of the Trade Union Act 1957, an unregistered union can be prosecuted using the name it used or is known by. Unregistered trade unions also unable to enter the contract with employer on behalf of members or employees, and if they do, the association or trade union may not be able to enforce the contract in their name. If an employee in a trade union has legally registered under their own name, they can initiate a lawsuit if the employer and the employer disagree. So that's all from me. Thank you.
Assalamualaikum, my name is SOFEA KHAIRI, and today I will be talking about rights to obtain financial support. Trade unions has always played a significant and important role in the industry, serving as a vanguard in defending workers' rights, financial well-being, health and safety. As the official member of any trade union, they deserve to enjoy their right to obtain financial support from the union they join. Any fines imposed and paid by the union can be obtained from the sales of its movable properties or any monetary help under its trust fund in compliance with the connected criminal proceedings, according to Section 25 Clause 5 of the Trade Unions Act 1959. Members significantly contribute to the financial support of the trade union by paying an entrance fee and a monthly membership subscription once they become members. A worker must pay an entrance fee and a monthly subscription of between RM3 and RM8 before being accepted as a member of a union. The money can only be used for the reasons specified in the Trade Union Act of 1959 and the Trade Unions Rules. According to the Trade Union Act of 1959, union funds can only be used for stated purposes, which include paying salaries for union employees, expenses for the upkeep of an office, expenses for the settlement of a trade union dispute, compensation to members for losses arising from trade dispute, such as a strike allowance and allowances for members and their families on account of death, old age, sickness, accident, or unemployment. The law, on the other hand, prevents unions from using their funds for any political reason, including donating to political parties. Unions are required to submit annual audited accounts to the Department of Trade Union for review in order to guarantee that union money is exclusively used for the reasons specified by law and the union constitution. After proper notice, failure to submit such accounts will result in the union's deregistration. Thank you.
Assalamualaikum to Dr. Samsudeen. My name is WAHIDA AMALIN binti ZULKIFLI. Now I'm going to present right to do industrial action. The reason why the industrial action happens is because of the unresolved disputes between employer and employees that seemed cannot be done only by negotiations. Under the Trade Unions Act 1959, the industrial action mentioned is strike and lockouts. The first form of industrial actions that has mentioned under the Trade Unions Act 1959 is strike. According to Section 2 of Trade Union Act 1959, strike means the cessation of work by a body of workmen acting in combination or a concerted refusal or a refusal under a common understanding of a number of workmen to continue to work or to accept employment, and includes any act or omission by a body of workmen acting in combination or under a common understanding which is intended to or does result in any limitation, restriction, reduction, or cessation of or dilatoriness in the performance or execution of the whole or any part of the duties connected with their employment. There are three types of strike, which are sympathy strike, political or general strike, and wildcat strike. The example of the strike case in Malaysia is Kesatuan Kebangsaan Pekerja-Pekerja Hotel, Bar dan Restoran Semenanjung Malaysia versus Crystal Crown Hotel and Resort Sdn Berhad, Crystal Crown Hotel Petaling Jaya, 2014 3MELR. In Malaysia, strikes are quite difficult to be performed by the employees because it consumes lots of time for confirmation, and not to mention there are also lots of procedures that need to be followed. For strike, trade unions must provide employers around 42 days notice before initiating a strike within 21 days of receiving the notice, and the trade union must not launch the strike before the notice's expiration date. A strike also considered valid when a trade union successfully follows all of the regulations of the Industrial Relations Act 1967 and Trade Unions Act 1959. Under Section 43, Clause 1 of Industrial Relations Act 1967, there is restriction, strikes and lockouts in essential services which no workman in any essential service shall go on strike without giving to the employer notice of strike within 42 days before striking, within 21 days of giving such notice, or before the expiry of the date of strike specified in any such notice aforesaid. If there is any strike found to be breached the rules or other written law and intended for other purposes besides the industrial disputes between employees and employers, the strikes are considered unlawful strikes. Thus, any trade union that wants to strike against the employer must follow the rules and regulations. Lastly, the form of industrial action under the Trade Unions Act 1959 is lockout. According to Section 2 of the Trade Union Act 1959, lockout means the closing of a place of employment, the suspension of work, or the refusal by an employer to continue to employ any number of workmen employed by him in furtherance of a trade dispute, done with a view to compelling those workmen to accept terms or conditions of or affecting employment. Lockout also happens when an employee is prevented from entering the workplace by the employer due to a strike or picket. that is done by the employee. In this way, it proves that the employer is accountable for making the employee employed rather than refusing the employee from working in such circumstances. Thus, lockout is caused by the acts of the employees that have conflicts with the employer over the organization's management.
For the conclusion, on the whole, there are 4 rights laid down by the Trade Union Act 1959 in order to protect the rights given to the members of the trade union as mentioned. These 4 rights, which include the right to legal action, the right to financial support, and the right to be presented in court proceedings, and the right to industrial action, which are significant in order for the union to avoid all the mistreatment and support for the growth of the industry in Malaysia. It is also clear that these rights are important for a trade union to protect their well-being and reduce the trade disputes. It also needs to be highlighted on how it is crucial for someone in the industry world to know their rights so that they will not easily be exploited by cruel employers that only set their goals on profits and couldn't care less about the well-being of their workers. Working involves dignity, and so all employers ought to be treated humanly by their employers. Furthermore, the rights given by the Act can also reduce the tension that results in trade disputes. When there are fewer trade disputes, it results in a more harmonious industrial relations and thus will benefit the country economically.